Thank you very much, Kevin. It's now my pleasure to introduce our initial keynote speaker, Dr. Gillian Hadfield. Dr. Hadfield is the Richard L. and Antoinette Chamois Kirtland Professor of Law and Professor of Economics at the University of Southern California. I will not attempt to list her many outstanding accomplishments because I'm sure you would rather hear her speak than listen to me introduce her. I will, however, observe that she's no stranger to Canada, having started her university education at Queen's, where she earned an honors BA in economics, and having taught for a number of years in the law faculty at the University of Toronto. She earned a JD and a PhD at Stanford and taught and has been a visitor at a number of outstanding universities across North America, including not only the University of Toronto, but also Harvard and Columbia. Her research interests include the design of legal and dispute resolution systems in advanced and developing market economies, contract law and theory, and the regulation of legal markets and the legal profession. The title of her presentation this evening is Reinventing Law Schools. Please join me in giving a warm welcome to Dr. Gillian Hadfield.
Oh, here we go. Okay. Yeah, so we're starting off with the government's cutting the budget, the Law Society's coming to get you, and we're all going to be turning out skills, high skills person. I can tell you exactly what the response from everybody in law school is as soon as you mention the word skills, because I spend most of my time trying to convince people it's not such a terrible thing. But what I want to do is, let's see, is this on? Yeah, okay. So reinventing law school. School is in parentheses because I think the whole question we're exploring about the future of law schools, and I guarantee they're going to look different in 10 years. How's that? Even though they haven't looked any different over the last 150. It's not even just 40 years, it's 150. I want to start us off with the big picture. Everybody's talking about changes in legal education, and a lot of it makes you feel like you're about to put on your gray sackcloth, and it's going to become this whole thing. People are talking about clinics. They're talking about doing away with a year. Even President Obama is saying it should just be 2 years. We have people talking about needs to cut tuition, need to put things online, and all of this. So I want to start off with the big picture. And the reason for that is to convince you that what we're seeing, the pressures we're experiencing, and the reasons that we have to be thinking about how we're going to change are because of some pretty deep and pretty important things that are changing. And we actually do something that's really very important. And most of the time, I don't spend my time thinking about legal education. I spend my time thinking about the bigger question about what is law. So let's start off. I want to start off with a bit of a detour. Maybe it's like some deep breathing exercises to sort of exercise his intellectual muscles before we start talking about the terrifying, boring stuff. So is that big enough, do you think? The history of human invention. This is, in fact, what I really spend my time thinking about, because law is this amazing thing. And we have a story about where most of the key important inventions in human society, when they emerged, right? The archaeologists can tell us that the Acheulean axe, this little hand axe, emerges about 1.5 million years ago. And then we get fire, we get houses, we get spears, we get modern humans with tools, we get clothing, then we get speech, we get communication. We move along. This is going pretty slowly, right? You can tell this is not to scale, I hope. We get art, we get music, and then we get agriculture. We get irrigation. Things start to speed up. We get writing. We get cities. Does this? Let's see, which is mine. Yeah. Ancient Babylon. Cities, political organization. One of my favorites, math. And another one, money, numbers, right? Yeah, because the stirrup, there's a long pause in this new time frame, and then it just takes off, right? Printing press, iron plow, science, calendars, wide rules, microscopes, smelting, steam engine, factory, electricity, computer. Obviously, there's some things missing from here, but it's an amazing thing, this process of human invention. And one of the wonderful things about our job is you get to spend time creating timelines like this, even though, I don't know, whose job is that to come up with those timelines? Okay, so when was law invented? And what does it mean to say law? Was law invented? I think it's really important we recognize that it's a human invention. Well, if you're going to answer the question, when was law invented, you've got to have some idea about what do you mean by law. And in fact, Barry Weingast and I, as a political scientist at Stanford, have been writing a series of articles, the first one of which has the unassuming title of What is Law? So what do most people think of when we think of what is law? We define it in the way that we experience on an ongoing basis in law schools and legal scholarship, modern legal scholarship. Law is a set of rules created by a government, enforced by that government. So we think of all the familiar things in law, the nation state, legislatures, courts, and police, and so on. And so we think we say, well, that's what law is. Law is that collection of institutions, and a lot of the rule-building exercises around the world, of which there's no shortage. Billions and billions of dollars spent around the world on trying to build rule of law have generally focused on this idea, oh, we got to go build more of those. And most of the people doing that building are lawyers and judges out there saying, this is what we need. This is what Africa needs. This is what Iraq needs. Right? Well, there was stuff going on before the state. The state's a relatively recent development. There was stuff going on. The Greeks and the Romans had stuff we would clearly recognize as law, constitutions, juries, codes, the Roman 12 tables, as mentioned, juries. Okay, so that's, for those, 4th, 5th, 6th century, so BC, before BC. I mean, go back even further. We can go a couple of thousand years BC, and we have pretty recognizable things that we would think of as law. We have Egyptian judges, contract deeds, Hammurabis Code, and so on. Anything before that? Well, we know that in these societies that were involved in agriculture, those kinds of communities, we see chieftains, we see tribal councils of elders, we have mediators. Now we're really getting to it. Do we want to call that law? And before that, taboos, norms, you can't walk into a simple society, anthropologists will tell you, without just running into a thick web of norms. You can't just build that house any old way you want to. There's a lot of norms about how it will be done. Is that law? How do we want to think about that? Okay, so and now another brief detour on what I do on my summer holidays. I think about this kind of stuff, and I get to do things like go and take photographs. These are not very good photographs. I don't pretend that I'm a photographer here, but okay. So this was this summer in the Berlin Pergamon Museum. You know what that is? Somebody knows. Seriously? This is great. Or are you just shy? Hammurabis Code. Here we go. Hammurabis Code. Anybody know what it's famous for? If you think about it, what is it? Eye for an eye, tooth for tooth. Thank you for not being a plant, but that's what my son learned about it in grade 7 or 6 or something like that. It's quite famous for eye for an eye, tooth for a tooth. Now, of course, you already heard I'm an economist, and I actually went and read it. I didn't read it in cuneiform. This is a close-up. It consists of 282 of these little columns. Each one of those is a provision, and I didn't read it on the stone. I read it in a printout, translated, thank goodness. But I did things like, okay, count them up. What proportion of this is about, add an hour. Thank you. Guys, you know how long we've got left. Can I close? Yeah, that could be a problem. So you go and you read up. About 60% of Hammurabi's Code is provisions like the following. If anyone take over a field to till it and obtain no harvest therefrom, it must be proved that he did no work on the field, and he must deliver grain just as his neighbor raised to the owner of the field. That sounds awfully familiar. Is that real property law, contract law? 60% of it is this kind of what happens if you rent the ox and the ox gets gored in the marketplace and so on, and you don't want to be the woman who charges more in corn than coin for beer at the tavern because you'll get thrown in the river apparently. So that's what most of it's about. Okay, a little bit more. These are not coming up so clearly. This is now we get to Egypt in 2000 BC. This is papyrus. It's the tale of the eloquent peasant, which is the story of a peasant who is on the road. He's got his donkeys. The owner of the fields has blocked off the way, and the donkeys have wandered into the field to eat the barley, and of course eating the barley is a violation of the rules, and the peasant wants to appeal to a judge somewhere, some kind of a decision maker, to say this isn't the right way to understand what that rule means or how it should work. Okay, there we've got 16th century BC in Egypt. This is a decision in legal decision in a probate dispute. One of my favorites. This is a verdict in a dispute about cheese. And our first year curriculum, we can find papyrus, 2nd century BC, this code of civil procedure. Here's torts. This is a letter about bad wine. And my favorite as a contracts professor, the contract for the sale of a donkey from Egypt in the 4th century BC. So we've been doing this a very long time. And it's important stuff in, right? Cheese, bad wine, donkeys, fields, right? Ordinary stuff. Okay, now I didn't go to Iceland this summer, but I have spent my time in my summers when I get to write thinking about Iceland. Does anybody recognize this? If you didn't, it's the Althing. Yes, it is. Law Rock, the Althing, medieval Iceland, which for Barry and I in our project on What is Law is, I think, just one of our favorite places. It's a canonical example of what we end up saying is quite essential about law, which is not about courts per se, not about states. Medieval Iceland had no government, had no police, had no jails, had no soldiers, but they had a ton of law. They would meet annually at the Althing. They'd come up with a bunch of rules. They would elect, they paid one public official, known as the law speaker, who was elected for a 3-year term from the population of legal scholars in the community, and whose job it was to memorize all the law and repeat it and to be available to resolve any disputes about what the law said. It was the only thing, and that for us is one thing that's essential. So what's this all about? This is all about the critical role of a community of legal scholars, a community of people who are what we think of as the stewards of legal reasoning. And I think this is a really important thing for us to know about our history as lawyers, law professors, legal scholars, is that law fundamentally has relied on the protection provided to legal reasoning by people like us. People join our group and learn how to do what we do, and that plays a critical role in providing all the social and economic structure that helped build those great cities in Babylon, ancient Egypt, and through to the modern day. Now there's a downside to being the stewards of legal reasoning. It's a pretty insular club, right? Over time, we've kind of drawn the line. Very insular. Carl, he knows what all those other disciplines would say, right? We keep to ourselves about this insular club. In fact, this is what some of the opponents of of all the pressures for change have started to say. I don't know if you've ever seen reference to this quotation. It's from Larry Fox, who was one of the big opponents of some changes in the ABA to introduce multidisciplinary practice. He said, we can't do that because we are a priesthood. We cannot let anybody else in because we will undermine that. Now again, that has a resonance with some of the things that are important, but it also gets a bit creepy and worrisome. It's evolved into only we can practice law. And a notion that we as lawyers don't answer to anyone. And I'm sorry to say, this is a quote from the Canadian Bar Association explaining why, although governments have to make sure that they regulate services consistent with the requirements of the General Agreement on Trade and Services, GATS, the position of the Bar Association is we don't have to answer to anyone. We're outside of the state. We don't have to justify the way that everybody else has to justify under the international regimes that our regulations are necessary for their purposes and are not just anti-competitive and keeping out others from our field. Our view is that the legal profession should not have to prove this. So that's where we start to get problematic. You'll know that the main complaint about lawyers is that they're arrogant, right? And they don't return phone calls. But so there's where we are. We've evolved to a point where a lot of people in one way or another really do think that the job of lawyers and law societies and law schools is to promote the interests of lawyers and law students and the ones we'd like to be our law students and law professors. A lot of the research in legal sociology, for example, I love all those sociologists, a lot of that research is on how are we doing, right? How much inequality is there in law? How much diversity is there in law? When we think about diversity and promoting diversity, we think about our student bodies. But we don't necessarily think very much about what's going on outside that. So we've become, I think, vulnerable to this critique. And it's not lost on the general population. For God's sake, stay as far away as you can from the legal system, unless, of course, you're a lawyer, because it's not so bad for lawyers. And that insularity, which has this I think they say, this very important history. We know what those papyri were being written for. They were being written for a community of people. The reason we know about Hammurabis Code is because for 1,000 years, law students were copying it down. But that insularity, self-interest, and finally that led us, unfortunately, to a place where we have failed the public on multiple fronts. So I don't think the pressures on law schools are about budget cutting per se, and I don't think they're just about whether or not we're producing skilled enough graduates. All the things which are real we need to deal with. I think it has to do with how we're executing on our fundamental obligation to the public. And this is why we have many of them now asking us for a completely different legal system. We're hearing that from corporate clients. I want something different. I spent a lot of time interviewing general counsel in Silicon Valley, asking them, well, how well is the legal system working for you? Not so well is the answer. We're not very happy with it. Ordinary citizens who really just don't have any capacity to get access into the system. And poor countries, those countries that are trying to build legal order in order to gain the benefits of a market democracy, are complaining about the structure we have. A lot of those projects have failed. What are the complaints? It's too expensive. It's too complex. It's too slow. And it's just not doing what we need it to do. And you have to go out and talk to people to find out that this is really what we're hearing. And you might hear little bits and pieces of it. But get outside of the bubble, and this is what you will hear. You can see it reflected in things you probably have spent some time thinking about. The crisis, and it is a crisis, of access to justice. Pretty much nobody has access to lawyers except corporations, extremely wealthy people, and maybe those who are still poor enough to get the benefit of legal aid. Right. Pretty much everybody else is just not something you can do. Now, it's even worse in the US than it is here, and it's worse here than it is in the UK, although it's going to be worse in the UK soon, but it's a real crisis. This is what is going on with, of course, the agitation around tort reform, which has been with us for 20, 30 years. That's people saying it's too expensive, too slow, not doing what we need it to do. We see this in the failures of law and development. Massively failed, extremely expensive, massively failed efforts to build legal order around the world in places that desperately need it. And the collapse in the demand for big law, which I don't know how much it's affecting you here, but it has led to a reduction in applications to law schools in the U.S. on the order of 15% every year for the last 4. And massive drop in, and these are at the high end. Actually, we're getting more of a reduction at the high end than the low end. And a lot of that is coming around from the fact that large corporate clients are saying, we're just not willing to pay for this anymore. General counsel saying, we will not pay for first-year associates. Some of them are saying second-year associates. Some of them are saying third-year associates on the bill. And sure enough, law firms are not hiring those folks in the same way. Okay. So we're getting pressures. This one's been around for a while. We need more ADR. We've been hearing that for 20 years or so. Of course, it hasn't worked out so well because arbitration is now just about as expensive as litigation. We got to license non-lawyers. That's a more recent call. Some people have been calling for that for a long time, but it's starting to come up. So we have the licensing of paralegals in Ontario. Washington State has just been the first U.S. state that has licensed, is rolling out a license for what they call, it's a terrible name, limited license legal technicians. You can see there was a lot of bargaining going on with the Bar Association over that one. Limited license legal technicians who will be allowed to assist in family law cases. California is starting to look at this, amazingly enough. New York is looking at establishing a pilot program on this. The ABA just released a report that says this is something we've got to be thinking about, but that's the pressure. We're getting the pressure to authorize ABSs. Okay, how many people know what an ABS is? Kevin, I'm guessing you do. Okay, great. Actually, I was going to expect nobody at my law school would know what an ABS is. I think alternative business structure, which is, of course, what has just come under authorization in the UK. I guess there's 4 law societies right now in Canada, I understand, that are starting to look at this. These are those entities. This is, by the way, the Larry Fox's quote about "we are a priesthood" is in the context of an effort at the ABA maybe 10 years ago to allow non-lawyers to have ownership, management, participation in legal businesses. So this is you might have heard referred to as the outside equity problem. I think that distorts the question. It's really about non-lawyers participating. Non-lawyers. You know there's no term non-doctors, right? We only have non-lawyers. So we're getting that pressure. You'll hear about this more also from Richard Susskind, I'm sure. Increase the use of technology. We heard about that in the legal education front. Make it cheaper, make it cheaper. Can't we let computers review those documents instead of those first-year, second-year, and third-year associates? It's a heck of a lot cheaper. And fix law school. All right, so this is the context in which these questions are coming up. So I don't think it's just because we're getting pressure to cut back on our budgets, and it's not just because the Law Society is saying, you know, hey, we would like your students to know how to do more when they arrive. So what's the role of the law schools? Every single person involved in this business was inducted, use that advisedly, inducted and educated by us, right? We actually created all of these people. We educated them. They may have had some ideas of their own after they left. Other institutions and structures may have influenced them, but we are playing a critical role in creating that population. And we are not just another or only a liberal arts faculty. Now let's admit it, that's why a lot of us are our law professors. I started off with my research of Barry Weingast, and to show you that I do things like, I'm a nerd, right? I'm a total nerd. I like to go around and take pictures of Egyptian papyrus, and I get really excited about seeing Hammurabis Code, take little close-up pictures of it. I write about these highly abstract questions about law and the evolution of law over thousands of years. I'll take on the best of you on sort of the liberal arts and the social science component of this. But nonetheless, we operate within a law school that plays this extremely important role in generating an extremely important piece of how society is organized. And it's not about becoming a trade school. And this is the other part of the skills conversation. I can't tell you how many times this conversation devolves into skills trade school. I don't want to have anything to do with this because you're turning us into a trade school. I'm an intellectual. I'm not working for a trade school. And that's not what it's at all about. The type of stuff that we're talking about, the type of change that's needed in law schools is really demanding intellectual work. And I disagree with President Obama and, about the idea that we could do what the top schools do in 2 years. Frankly, I think we'd probably need more. But it's not about dumbing down. Oh, all you need to do is teach them what form to fill out, you know, what room to go to, right, which hallway to enter. It's about some pretty important and difficult work. But we need to be thinking about how we teach. We need to be thinking about what we teach and who we teach. The whole ball of wax. And this, I think, what's going to be hugely challenging. It's also incredibly exciting in many ways, and that's why I partly also want you to start off with the big picture, to say this is a very important, I think, call for us to reinvent what we do. Okay, so what about how we teach? Okay, Kevin's already referred to this. How do we teach? Well, we got the appellate case method. We read all those cases. We've got large classes. Sometimes we lecture to them. Sometimes we engage in something that people call Socratic dialogue, which I don't really think is Socratic dialogue, and we do give people exams and papers, often 100% final exams papers. They were doing it in the paper chase. They were doing it long before that. What do we teach? We teach legal rules. We teach the culture of legal reasoning. Right? We induct people into the culture of how would a lawyer think about that? How would a lawyer look at that? I think it's a very critical thing that we do, because it means that if I don't practice law, but if I did, if I was on one side of a case and Kevin was on the other side of a case, and we don't meet, we don't talk, your client comes in, my client comes in, we already have a pretty good idea about how each of us will be thinking and how we'll respond to different kinds of arguments. With this important coordinating function performed by the culture of legal reasoning. I think that's a very important thing we're doing. And we're teaching theory and policy. We're teaching about what contracts do, why they do it. We're talking about policy. What would be good rules? What should the Constitution say? Right? So that's pretty much what we're teaching. And who are we teaching? We're teaching elite graduate students. By graduate, I mean post-baccalaureate. We're training one thing, one-size-fits-all legal practitioner, lawyer. And some of those will go on and be judges, some small slice of them. And we don't think about this, we are training those who are going to hold and regulate the professional monopoly. The members of the Law Society who are going to make those decisions about what the law school's got to do, whether you can have ABSs, whether you're going to license non-lawyers, and so on. We don't spend very much time at all thinking about that function, about who we're educating. Okay, so this is the point about it. It's actually 150 years old. This is the Harvard model from about 1870. What were they doing? They were educating elites. They were very self-conscious about this as well at Harvard. We're educating elites with the appellate case method to produce the judges and appellate bar who will craft the common law, which is, of course, a lot of policy there. So that's why we do what we do. Why are you reading appellate cases? Because you're going to be engaged in appellate reasoning. Okay, so what do we do well? Educating elites with appellate case method to produce the judges and appellate bar who craft the policy of the common law. Right? That's what we do pretty well. What don't we do well? We don't teach a practice. I don't mean what form to fill in. I mean a practice in the same way that being a doctor is a practice, that being a priest is a practice, that being a teacher is a practice. I spent some time talking with a wonderful colleague at the education school at Stanford who studies the teaching of practice. And so she goes around and looks at seminary schools and education schools and medical schools and so on. And there's a strong sense of we're bringing up novitiates in our practice. We don't really do that. We really don't teach problem solving. We teach a certain kind of problem solving, how to solve a problem in legal reasoning. But we don't really teach how to solve a bigger problem that's out there that our clients may be facing. We don't spend very much time thinking about the cost effectiveness of practices or encouraging our students to have some framework for thinking about, is this worth it? How would we decide which of these procedures we should follow? We don't produce a diverse array of suppliers. We produce one thing, a lawyer, all the same everywhere, take the same set of exams, meet the same set of requirements, pass the same licensing, subject to the same set of legal ethics, authorized to practice in exactly the same way. Right? There's no differentiation in that group. We don't teach people how to think about innovating the system. We teach really creative people. We all love our students. We have very smart students. They are very smart lawyers. This is not about the lack of inherent creativity or whatever. But we're not teaching people to think about the innovation of this system. So I have an article where I talk about some of the ways in which I teach and the ways in which I think about, we really need to think, where are our garage guys in law? Where are the people who are rethinking how we do law, how we do it from the ground up, right? How we accomplish what law needs to accomplish. And we're not doing a very good job at generating the, I think, expertise and ethics necessary for regulating and designing legal systems. And this is a big, big failing. Because we've come to think of legal ethics as about obligations to clients. And of course, a lot of our legal ethics is really a cover for the structural limits we put on who else can practice, not you folks over there. And not the more fundamental ethic of our obligation to make sure that we're not abusing that power by keeping people out who shouldn't be out. And it takes expertise. The way a lot of law societies and bar associations fulfill their obligation to regulate the system is through lawyerly discussion, maybe a little research, not much. Here's the New York Bar Association's approach to answering the question of what should we do about this question of allowing outside investment into legal businesses. Well, they did a survey, a little empirical. They surveyed lawyers. They said, lawyers, do you think we should do this? 78% said, no, we don't. Well, guess what? There's no need for this. I'm saying, survey me. Because there's a lot of those ordinary citizens out there, a lot of the corporate clients out there who would say, oh, we need this. We could do some economic analysis. I could tell you why we need it. Okay, so you have to promise me that if Richard Susskind puts up this picture, you will pretend you've never seen it. Okay? Because I got this from Mark Chandler, who was general counsel at Cisco, was one of the GCs that I was interviewing for a project a while ago. But Richard talks about this in one of his books, and Mark may have got it from Richard, and I may be cribbing it now, in fact, from Richard. So again, if Richard's using this, you got to go along with it. So the story, no doubt an apocryphal one, is Black & Decker at their training sessions for their new employees. Bring them all into the room and show them this picture and ask them, is this what we produce? And of course, they all look around and, yeah, that's what we produce. And they say, wrong. This is what we produce. Holes and pieces of wood. Drills are just a way of doing that. And the reason Susskind uses this, the reason Mark Chandler, who's one of the most innovative general counsel around, who talks a lot about these issues, uses this is to say, we got all focused on the drill and we forgot about the thing we're supposed to be trying to do, which is drill the hole in the board. We need to be thinking about that. So what can we do differently? Rethinking how we teach. We need to be giving our students a lot more opportunities to understand that law is an applied discipline. We are not just teaching them about law. We're teaching them how to do law, how to apply that knowledge. We need to be using many more teaching methods where students are actively engaged in problem solving. We need to give them opportunity after opportunity after opportunity to practice the practice. And I do practice what I preach. I teach first-year contracts with students in 4-person groups, working on problems right from the get-go. I teach an advanced contracts class on a team basis where I put together, actually I started this one at University of Toronto when I was there, worked with McCarthy-Tatro partners when I was there, who were fantastic, who pulled cases out of their files, wrote up narratives, sort of in the style of a Harvard Business School type case. It says, okay, you're the general counsel, or you're the outside counsel they've called from. Here's the letter, the draft that they've received. Here's the problem that they're facing. And I just hand it to them and go. My job in that class is to very quickly be the person who says nothing. I once couldn't show up for class. They still had the class. What they're doing is practicing, and they do 8 of those over the semester, and they get feedback on them, and then they do it again. So they have to just get into the sandbox and practice. It's fun. They like it. And I've had one student in my advanced contracts class say, at the end of it, he says, you know, before I took this class, 1, I didn't know if I wanted to be a lawyer, but 2, I didn't understand why I was reading all those cases last year in first year. Now, we think it's obvious why they're reading those cases. But talk to your students. They often have a very different perspective on what you think they're supposed to get out of it. A lot of them think reading all those cases is just an esoteric way of getting them to pull a one-line rule out. For God's sakes, just tell me the rule. Right? Why are you making... They're thinking of it, it's like reading history, or it's like their English teacher, or it's just kind of this esoteric way of getting at a rule. They don't know, actually, and then you discover this because you hand them a problem, and they really don't know what to do with facts. They don't know how to make an argument. Right? We think we're doing a good job at getting them to make arguments, but they didn't know what to do with it. He said, only now did I understand why I need to go actually read the case, not just because my professor always told me, make sure you read the facts in the case, because those are your tools. And they didn't know. Okay, rethinking what we teach. We need to be thinking about orienting our students to problem solving. They're not going to be standing in those appellate case rooms arguing those legal rules through very much of their career. Some of them will. Some tiny fraction of them will. But most of them are going to be helping people and organizations get things done. Complying with rules, accomplishing, organizing, setting up organizations, managing their relationships, dealing with disputes. We need to think about teaching them about our clients' context. You'll notice I'm not listing here a set of courses we should be teaching, right? Because what is client context? Well, in some cases, that's going to be understanding something about a business. It's going to be understanding something about environmental policy for some. It's going to be understanding about the dynamics of family breakdown, or how people respond to death in a family. Right? Understanding the world in which those problems are arising and the people who are coming to us for help live, and therefore how we will understand what their goals are, what their needs are, what their limits are. Right? That's why we need to understand. That's why I don't like to sort of say, get up here and say, you got to have a finance class, and you got to have an accounting class, and you have to have, and I get worried about the bar associations and the law societies that come in with that list. Right? Because I don't know what that is. For some of us, it's going to be, but we don't really give them that context. We need to give them more of that. We need to help them develop judgment. And by that, I mean the capacity, the capacity to look and say, that's a good argument, that's a bad argument. Here's a strategy, here's another strategy. Here's what you'd get out of this strategy, here's what you'd get out of that strategy. That's not going to be worth it, following that path. Exercising judgment which means weighing a lot of different variables and choosing a course of action. We really don't give our students much opportunity to do this. I focus on teaching this in my first-year classes. I grade them expressly on judgment. In the context there, it's that I take that standard first-year problem, you know, some complicated set of facts, advise your client, and I say, well, first of all, I want you just to identify all the issues you can see, all that good old issue spotting stuff. Don't analyze them, just identify them. And then I want you to choose one that you judge to be important to the advice you have to give. And just analyze that one in detail. This is the instructions on the final exam and on all the assignments we do during the semester. And they freak out at the idea about picking one. How do I know? You have to tell me how I should choose. Just choose. Just choose. We're going to post them all. We're going to talk about it. We're going to do it again and again and again. And guess what? By the time I get to the exam, 80% are getting full marks for choosing something. Yep, it would be important to understand that. Don't spend time on that cute little legal issue because the damages are like 50 cents. And there's multi-$100,000 problem over here, right? Or don't spend a lot of time on that version of the contract because the other side would have a terrific defense that there was no contract formed. Right? So that's exercising judgment in that context. And you can develop it. You can develop it. We need to be providing people with analytical tools for problem solving. There's a lot of these types of things. I mean, I think of things like I don't think anybody should really graduate. I said I wouldn't say this, but I don't think anybody should graduate law school without knowing how to do a decision tree, how to go through and say, here are the various things that could happen, and how could you work through various scenarios to decide where you'd put your resources and your efforts. Your clients are never going to want you. This is what they're complaining about. They don't want to pay you to do every last little bit of research on every last little issue. They want you to exercise judgment and make some decisions about where to go. They're using those kinds of tools. But the other tools are policy tools, very good intellectual tools. Remember, it's hard analytical work. This is not, you know, fill in form X. This is hard stuff. Integration, they need to learn how to integrate all this stuff. That's really hard. It's really hard. How do you integrate what you know about legal rules and what you know about legal reasoning and what you know about your client's context and your judgment and those policy considerations? How do you put that all together? And they need to understand something about legal policy making. We really just can't continue to say we're going to turn people out, and then once they're out there in the profession, sort of on this volunteer part-time basis, they'll make all these decisions about how law will be organized. Rethinking who we teach. I think my view of the future of the law school is educating lawyers is going to be one component. We need to be thinking, I believe, about general legal education for undergraduates. Because a lot more, we live in such a law-thick world, as I like to say. Lots of people need to have a basic understanding about how law works, which will make them less beholden to lawyers who say, oh, we can't do it this way, you've got to do it that way. We need to be able to push back a bit more. We need to be thinking about training a more diverse array of folks. I'm put up the label here. We don't yet know what to call it. I just know I don't want to call it limited licensed legal technicians, legal assistants, the equivalent of the nurse practitioner and the certified midwife and so on, right? The multiple types of providers. We need to, I think, be thinking about how we would provide legal analysis for other professionals. Because a lot of people who are using legal analysis who don't really need to or want to have to be totally, as I say, call in lawyer and not be able to have that conversation or participate in it, because a lot of this is about participating in a team-based process. I think we want to be thinking about how we will deepen expertise post-JD. This is why I don't think, I shudder at the idea it's 2 years to say a lot of the stuff I want my students to know how to do is going to take them quite a while to figure out how to do it. So maybe we don't do it all as part of our first law degree. We have people coming back to say, you know, deepen their expertise in environmental policy or family dynamics or business decision making. And I think we need to be thinking about how we're going to be sharing our expertise globally and extending that education to folks around the world. And if we don't do it soon, the chickens are coming home to roost. That's it. Can we get the lights up if we're going to? Well, they'll take a long time, but anyway, are you going to take? Do you want to take some questions or not?
Yeah.
It's up to you.
Yeah, no,
I can also talk over wine.
We came here because we wanted to talk. From my perspective, this was exactly the type of first session that I wanted us to have,
Great.
and so I'm delighted that Gillian gave that presentation. But why don't we take a few minutes for questions, and then we can carry on the discussion over something. Yeah. Yeah.
Yep. So I think that maybe take away from here that I think a lot of what we're dealing with is structural change in our economies, our societies, globalization. That's affecting everybody. So that's pressure on higher education. That's pressure on medicine. That's pressure on science. That's yes, across the board. So we are responding to the same type of shifts. What sets, and if you go back, sort of just thinking about the professions, you go back to the origins, and it's really important to remember this, that a lot of the restrictions that the profession has placed were kind of invented around the turn of the last century. And doctors invented them at the same time, and dentists and optometrists. That was the definite, we created the idea of a profession, the noble profession, the educated group, and self-governing, right? So that idea is the same. Here's what's different. Medicine has come under a lot of pressure, and we've seen change in that professional structure. We've had antitrust law that struck down the ways in which the doctors have restricted. We have, at least called in the U.S., I don't know if we call it here, corporate practice of medicine, corporate practice of law doctrine, which is the ABS question. A corporation cannot practice law. Well, there's a corporate practice of medicine doctrine that came around about the same time. Why does it disappear? Because you've got hospitals in the game, you've got nurses in the game, you've got other groups that come in and put on pressure to things, and at the end of the day, the legislature decides, because it's ultimately that. Well, that's why I put up the quote about what the Law Society says, the Bar Association say, which is we stand outside of that process. Right? It's not the legislature deciding what would be the best structure for the legal system. So I think what makes us special in law, and that makes us, we've been much more insular, we've changed much less. The medical schools are not teaching like they did at Harvard in 1870, thank God, right? And it's not just that the techniques have changed. They're not teaching in the same ways. So I think what makes us different is that we really hold ourselves apart from the whole process. And we just haven't been. Why has the UK changed so much? One, they didn't have as much regulation to begin with. But two, because they put a banker in charge of the review and who went in and said, "Are you nuts? Why are you running it like this?" Right? And I'm a big fan of what they're doing in the UK. You'll easily tell. Yeah, so the kinds of things that I think we need to be focusing on is, first of all, a much more diverse array of legal professionals, not just the one-size-fits-all JD. I think we need, like I say, legal assistants. We need people who have general legal education who aren't necessarily serving as a professional. So I think we need to open up, we need a much more diverse array. And I'm a big fan of the ABS in the sense of the organizational practice of law. I think the reason that law is very expensive, the reason that nobody who isn't either extremely rich or able to draw on limited legal aid dollars really has no access to legal help in crisis, much less legal advice about how to run your life, is because we have an extremely expensive model. It's extreme. I mean, you can't find lawyers who can work for, at least in the US, the number is sort of on the order of $200 an hour. It's not that they're taking home $200 an hour times 40 hours a week. A lot of that $200 is because of a highly inefficient solo small firm practice model. So I really think both to reduce costs and build quality, we need a lot more diverse forms of organizations that are producing law, that can build scale, that can leverage a lot of the things you get with scale, like brand and technology and protocols. Nurse practitioners operate under protocols, right? And they implement those protocols. That ensures quality and it reduces cost. We need a much wider drive. So that's my view. Differentiation and scale organizational change. Yeah. Yeah, it's, I mean, there's two things in your comment, right? The hardest part was getting in, which means it's not hard enough when you get here. Right? I think we don't, I mean, we scare them to death and we may have them doing a lot of stuff, but I don't think we really work in people's minds the way we need to be. But the other side, I really think that the competition to get into law school has had a very bad effect. That and again, I think this is even more intense in the US where there's incredible intense competition at the college level and so on, that, you know, I see a bunch of students who are, so I taught at Harvard last spring, and, you know, even with the collapse in legal hiring in the US, Harvard students are still doing pretty well in the job market. They were the most anxious people I'd ever met in my entire life, right? I had more, unfortunately, women in my office in tears that year than I'd had my entire career in teaching. They're locked down. We've encouraged them. They've been brought up since kindergarten. Just tell me what you want me to do. Which credential do you want me to get? What thing do you want me to get on my resume? Show me what you want, you know, just show me and I can do it. And I think that has had a bad effect. I think that's throughout higher education, and we've had that effect. But then we just add another layer on in law school, and I think, you know, if I'm saying where are the garage guys, I teach a course, Legal Innovation, Legal Design Lab, where I say all we're going to do in this course is you're going to come up with a proposal to do something different to fix a problem. And how do I encourage people to be creative and just to expand their minds to think about that? They have that capacity, but we beat it out of them a lot, and we make them jump through a whole lot of hoops that I think is problematic for who are getting into law school. Yeah. Yeah, it's really hard, and it does not make you popular. I know this very well. I know Jerry Hess is going to be here tomorrow, I guess. I don't think he's here, arrived yet. Jerry teaches at Gonzaga. I went to his teaching sessions, this must have been the early 90s. And when I was at U of T, I think in 96, 95, 96, I invited him to come and talk, because I was thinking about this stuff back then. I don't know why. I mean, maybe having the PhD in economics and coming in, I was saying, why are we teaching this when what we're testing is that? There was this big disconnect in what I saw. So I was very interested. I learned these wonderful techniques from him. I brought him into U of T. That's not what we do here, right? That makes us a trade school. If we do things like talk about or use words like experiential learning or whatever. I ran a retreat at USC last year. I think I got a few more people on board. There are people using the clickers in the classroom. I see you've got the signs up here. People use it, but it's hard to do. But we're not special on, medical schools, business schools, other parts of the university not doing it enough, but reinvent themselves more often than once every maybe 150 years. And I think maybe people in law are a little self-conscious about whether they really count as scholars in the same way that the human geographers and the physicists and the English professors and the economists do, maybe. So maybe there's more worry about that, but my view is you got to inspire people that it's what we need to be doing. It's not hard. I mean, I post, the Garage Guys article is mostly about how I teach my first year contracts and my upper year advanced contracts class. My materials are up there. I guarantee you I do not spend more time on my teaching than the average person in a law faculty. I do a lot of writing. I do a lot of speaking. I do a lot of publishing. This is not cutting into my bread and butter of spending my time thinking about the history of the invention of law. So I think we have to, and we have to recognize, so I want to say, this is a really big deal. This is a really big deal. We have to find it in ourselves to say we need to do this. Yeah. So it's true that we don't have everybody in the law school that we would like to have on the faculty, I think. But I don't practice law. I never have practiced law. I went straight from PhD and a law degree into law teaching in 1990, straight out of my graduate work. And one of the things I have done is go and talk to people who practice and think about it and say, well, how do I put myself, we're a smart bunch of people. So I can do that. I think a lot of people can. Not everybody on a faculty is going to be able to do it, but I think we have a much larger number than we perhaps say. And I'm not a believer that, we just need all those practitioners to come in and start teaching, because there's real expertise in teaching. Excuse me. This takes skill. It takes learning. It takes experience. And I think we need to make sure we're recognizing that, but we have to be deploying that. So we should be looking to partner with, so my advanced contracts class, I was so lucky to have this fantastic junior partner at McCarthy Tatro, who just was totally interested in doing this with me. Set up the meetings with the partners, brought me in, said what kinds of problems should we look for, and the lawyers wrote up the cases. They fictionalized it, they redacted the documents, and then he came in and taught it with me for the first year. So I could gain some confidence that I wasn't just some theoretical, well, wouldn't you say this to your client, right? I could sort of, so you can do that. And a lot of what we're talking about improving is the stuff we already think we're doing well, that we're well equipped. We think we're teaching students how to use cases to argue and craft legal advice. And my observation is that when you actually have them do that, they don't know how to do it. Our methods aren't working. So we don't all have to be the person. It's not about tactics, and there's a lot of stuff that will come on the outside, but think about the models of the medical school. They have a very diverse faculty. They integrate a lot of people, but everybody knows that they're part of the same project. So I think we could do a lot with what we've got.
Well, thank you very much.
Thank you, everybody.